Hi, I'm Emily and I am here with Maya Murphy's attorney, Lauren MacDonald. Attorney MacDonald practices at Maya Murphy's Westport, Connecticut office and is admitted to practice law in both Connecticut and New York. My questions today for Attorney MacDonald are, what factors can a Connecticut school district consider when determining whether my child will serve an out-of-school suspension? And what are my child's rights after an informal hearing when the school district imposes a suspension?
These are very important questions, Emily. Thank you for asking. The Connecticut State Department of Education has recommended that administrators should consider the following mitigating factors before moving ahead with out-of-school suspensions. First, the age, grade, and developmental stage of a student. A younger child may not have the developmental maturity to understand that his or her conduct is inappropriate in a school setting. Alternative behavior support programs educating him or her about this fact could be a more effective and less severe form of discipline. Second, administrators should look to the student's reasons for engaging in misbehavior. If the student did not intend to harm someone or something, but was acting out of frustration, then an out-of-school suspension may be unwarranted under the circumstances because it would not effectively address the underlying problems. Examples of mitigating reasons include teasing or bullying by peers and family issues. Third, administrators should look to the student's past disciplinary problems and likelihood of reoccurrence. If the student does not have a disciplinary history, then an out-of-school suspension could be unnecessarily harsh. Instead, an in-school suspension or another behavioral support program could be equally as effective in punishing and deterring the student from engaging in misconduct in the future. But if the student does have a history of disciplinary problems, an out-of-school suspension could be the next logical step in addressing the student's behavior. Fourth, administrators should look to the risk of loss of instruction. If a student is disengaging from class, an out-of-school suspension may compromise academic performance and actually exacerbate the student's lack of interest in school. Six, administrators should look at cultural factors. A student could misbehave due to a misunderstanding and different interpretations of events based on race, ethnicity, and linguistic differences. And lastly, administrators should look to the extent of parental support in addressing the student's behavior. Administrators should consult with parents whenever a student is misbehaving in school. If there is not a history of such collaboration between parents and the school, then the school should involve parents in addressing a student's misconduct before moving on to more serious measures. If the school administration does proceed with an in-school suspension, the student can, depending on the administration's preference, serve the suspension in the school or in a different school under the jurisdiction of the local or regional board of education. If the administration authorizes a suspension after an informal hearing, parents cannot appeal the decision. However, the school must give the student the opportunity to complete homework, including examinations, which he or she missed during the suspension period. Under the law, schools also cannot use out-of-school suspensions to discipline students more than 10 times or 50 days during the school year, whichever comes first, without convening a more formal hearing. The limit for in-school suspensions is 15 times or 50 school days during the school year. If the administration does impose an in-school suspension, parents should note that the Department of Education has issued guidance on what they consider an effective in-school suspension program. First, the program should have a strong academic focus. To that end, the department recommends that administrators group students together by age or grade and have the group supervised by a qualified individual. School officials should also keep the student-to-teacher ratio low and have certified teachers in essential areas such as math or reading to provide instruction to students. Along with providing students with an academically oriented program, administrators must allow students to receive and complete schoolwork from their regular classroom. Second, the The suspension program should include strong counseling components so students can get the necessary support to correct their inappropriate behavior. Accordingly, guidance counselors, social workers, or psychologists should be available to students in the in-school suspension room. Quality programs should help the student manage his or her emotions, handle challenging situations more effectively, and develop positive relationships with both students and teachers. Feel free to give me a call if you have any questions about your child's rights after they have been suspended.
Attorney MacDonald is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney MacDonald at lmacdonald@mylaw.com, and please visit mylaw.com for more information.